agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government, love the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Trey Orndorff, a political scientist at Oklahoma Christian University, and I'm joined for our midweek show by Ken Katkin, a professor of law at Chase School of Law in Northern Kentucky. Welcome to the midweek show, Ken.
Thanks, Trey. It's great to be back again.
Yeah, I mean, my guess is at some point you're going to get tired of hearing me. I don't know. So on the weekend show on Saturday, Ken and I we had a number of court cases and constitutional law issues. And if you haven't heard that show, I highly recommend that you go back and take a listen to that. It was a lot of fun. And if you enjoyed that, you're going to love today's show because we actually kind of want to pick up with this past week's some of the really big court cases that are occurring, one that's finished and one that's in process. And I want to start, Ken, by talking about Timbs versus Indiana. And so for listeners who may or may not be in on this, this case is about incorporation. And what that means is so once upon a time, when the Constitution was written and then the Bill of Rights are added as a result to get the Constitution passed, it's a concession to anti-federalists. And the purpose of the Bill of Rights was to restrict the national government's ability to interfere with citizens' rights, because that's what the worry was. So your Bill of Rights, they didn't apply to what happened at the state level. So that didn't apply to the state legislature of Kentucky or Oklahoma or Florida. But then after the Civil War, we have the 14th Amendment is passed. And what the 14th Amendment says, in part, there's more to it, of course, but in part, for our purposes here, it says that there are some fundamental rights that all American citizens have, and therefore can't be abridged either by the national government or, and this is key, state governments. And so what slowly but surely began to happen was the process of taking pieces, almost kind of like with I like thinking of it like tweezers. The Supreme Court would like take a teeny little itty bitty piece out of the Bill of Rights and say, via the 14th Amendment, we're now going to apply this to the states. And what we mean by that is that states would then have to respect that right. That Bill of Rights. And that's the process of incorporation. So here enters in this past week, the decision in Timbs v. Indiana, when Tyson Timbs, he purchased a Land Rover for about $42,000 a few years ago in January in 2013. And what ends up happening is that he used this vehicle while he's transporting heroin. And so he is charged, the state, importantly here, Indiana charges him with a number of felony crimes. He ends up doing a plea deal so that he ends up just pleading guilty to one charge. He gets a largely suspended sentence, and then he has to pay some fines and fees. Well, the state additionally wants to forfeit his Land Rover, and the lower courts will all say, look, you can't do this because that's an excessive fine, because in Indiana, the maximum statutory fine for Tim's felony is a $10,000 charge, and his vehicle, even with depreciation, is worth at least about 3 or 4 times that. The Indiana Supreme Court reversed those lower court decisions and said, no, actually, the Supreme Court has never incorporated this portion of the Eighth Amendment, and therefore it has not come to us via the 14th Amendment, and therefore the state can forfeiture whatever they want because the Eighth Amendment does not apply. What's interesting about this, Ken, I've got some deep questions for you on this, is that it's a majority opinion. We have a 9-0 opinion here that says, look, if we haven't made it explicit, it's explicit now, and they hadn't, and it is, that the Eighth Amendment, the excessive fines portion, applies to states. As a matter of fact, Ginsburg will say that it is, in fact, a, quote, fundamental to our scheme of ordered liberty, end quote. And the reason that's important is that is the standard by which whether something is going to be included or not included in that incorporation process. And so they'll apply it. But now there's two interesting concurring opinions where Gorsuch and Thomas, they both agree in whole, but both of them would argue that they shouldn't use the 14th Amendment's privileges or immunities clause. They argue that it needs to use the due process clause, and they both note that the court has always gotten this wrong. And I actually had to read that twice because I've been teaching this for a while, and I thought that's what they've always done. So Ken, this is what's happened. This is an interesting one. It's big news just because we've now incorporated a new right. And that's a huge deal. But also, I'm interested in your take on these concurring.
Yeah,
opinions.
I just want to correct. I think you had it backwards. The court used the due process clause, and the Thomas and Gorsuch opinion said they should use the privileges or immunities clause.
Yeah.
Okay, yeah. Okay.
Yes. Thank you for that, Ken.
Yeah. Well, that's a much more theoretical debate than practical debate. Although Thomas has some reasons he thinks it's a practical debate as well. There's no question that as an original matter, Thomas is right about this. The author of the 14th Amendment of that language was Congressman John Bingham of Youngstown, Ohio, and he gave hundreds of speeches. He wrote hundreds of newspaper articles. He was a vigorous campaigner for incorporation of the Bill of Rights, and that's what the 14th Amendment should do. He'd been actually interested in that issue for almost 30 years. Ever since the Supreme Court had decided a case called Barron versus Baltimore in the 1830s that held that the original Bill of Rights didn't apply to the states, and
the initiation of the idea of dual citizenship, meaning you're both a citizen of a state and of the national government.
I mean, Bingham always thought that the Bill of Rights, that rights like freedom of speech and free exercise of religion, that if people are going to be able to enjoy those rights, that means that both the federal government and the state and local governments shouldn't infringe those rights. But as you correctly pointed out, that was probably not the original understanding of the Bill of Rights in 1791. And the Barron Court in the 1830s follows the original understanding of the Bill of Rights and says the Bill of Rights only restricts the United States government. It doesn't apply to state and local governments. So Bingham is one of the leading political figures in the 19th century who wants to change that. And he succeeds more or less in changing that because the 14th Amendment gets ratified. He gets to write this language. He goes out and argues in favor of ratification. And he makes it super clear that the language in the 14th Amendment that he thinks is the language that he wrote that will incorporate the Bill of Rights and make the Bill of Rights apply against state and local governments is the Privileges and Immunities Clause, which is what Thomas is saying now. And Bingham would even explain that privileges and immunities, that phrase, is a synonym for rights and freedoms. Privileges means essentially the same thing as rights. Immunities means essentially the same thing as freedoms. And the rights and freedoms that are protected in the Bill of Rights are the rights and freedoms that he wants to protect. Now, the reason he doesn't literally use the phrase Bill of Rights instead of using the more oblique phrase privileges and immunities is because in addition to the Bill of Rights, the original Constitution had a separate provision in Article 4, Section 2 that was called the Privileges and Immunities Clause of Article 4, Section 2. And it largely protects citizens of one state against discrimination when they travel into other states, being discriminated against because they're from out of states. And he liked that language because he thought it both sounded like the Bill of Rights, so he liked that, but also that he thought that the 14th Amendment should now be interpreted not only to prevent citizens to prevent states from discriminating against out-of-state citizens, but also to prevent states from discriminating as between their own citizens. And that, of course, was thinking about the newly freed slaves, that he wanted them to have full first-class citizenship in their own states. So he thought that language kind of did both, but actually the language was a little bit, it made it easier to, it made it less explicit that he's talking about the Bill of Rights. And that caused problems because one of the first cases ever decided under the 14th Amendment was a case called the Slaughterhouse Cases. It gets decided in 1873, so that's just 5 years after the 14th Amendment was ratified. It doesn't actually involve anything in the Bill of Rights. It only involves some other kinds of claims. But the court in the Slaughterhouse Cases gives such a restrictive reading of the Privileges and Immunities Clause that they basically nullified the clause. And so even though that had been the clause that the principal author of the language thought would incorporate the Bill of Rights, the court held that clause really didn't do anything. And so that set back the incorporation of the Bill of Rights by about 50 years. And then 50 years
Right, because it really doesn't end up happening until 1937 in Polka,
It
Connecticut,
starts
correct?
happening a little sooner. Gitlow versus New York is from 1925, and that incorporates the free
Okay.
speech clause. Near versus Minnesota also incorporates the free press clause. So there's a couple of scattershot incorporation cases before the Palco case. Although Palco comes up with the formulation that you talked about, implicit in a system of ordered liberty. Those rights that are implicit in a system of ordered liberty must be the rights that are protected by the word liberty in the due process clause, which says that no state can deprive any person of life, liberty, or property without due process of law. So that's how the court comes.
And that remains the holding, though,
Yeah,
currently,
yeah,
does it
that's the
not?
test. So that's the same test they were applying. Yeah,
That's what I
yeah.
thought.
So
Okay.
that formula, that verbal formulation, you're correct to say that comes from the 1937 case of Palco versus Connecticut. But that case, there had been some cases that had incorporated some First Amendment rights, and also a case that had incorporated the Fifth Amendment takings clause even before Palco versus Connecticut. So Palco came up with the formulation, but it wasn't the first actual incorporation case. Yeah. So anyhow, so that a lot of that is in the nature of legal theory. Because the court didn't use the Privileges and Immunities Clause, though, to give us full-fledged incorporation of the Bill of Rights, and instead they stumbled on this other formulation where they said, well, okay, we don't have full-fledged incorporation of the Bill of Rights, but we'll only incorporate those particular rights that are in the Bill of Rights that are implicit in a system of ordered liberty. That meant that there's a half century of cases, largely from the 20s to the late 60s, where the court one by one is going through all the rights in the Bill of Rights and deciding whether to incorporate them or not.
Which
Yeah,
ones?
and they end up incorporating substantially
Yeah.
all of them. There's a few that they still haven't. So as recently as 2010, they had not incorporated the Second Amendment right to bear arms, but they did incorporate
Right.
that one in 2010 in the case of McDonald versus the city of Chicago. And now in the case that was decided this week, they finally incorporated the excessive fines. I think the ones that still remain unincorporated even today are the Fifth Amendment right to grand jury indictment. So states are allowed to use different methods other than grand jury indictment to start to charge people with crimes and start a criminal prosecution. And the Seventh Amendment right to civil jury trial. So in civil suits like the defamation suits we were talking about with Nick Sandman in the Washington Post, if those, yeah,
As a reminder, that was the bonus show, listeners. So if you want to hear more about Nick Salmon and the suit against the Washington Post, you'll actually have to you'll have to become a supporter, and you'll have access to our supporter only shows. But that's what we had been talking about this past weekend on the supporter show. But continue.
Yeah. So
Ken,
that
continue.
case was brought in federal district court. So that means that because of the Seventh Amendment, if it goes to trial, then the litigants will have the right to demand a jury trial. The court can't just impose a bench trial on them. But in states, states are not bound by that rule. So states are allowed to require bench trials in civil actions. There doesn't have to be jury trials as long as it's not a criminal prosecution. So that one still hasn't. And then the other one that still hasn't been incorporated is just simply because it hasn't come up is the Third Amendment right against having to quarter soldiers in your home. There hasn't really been a proper case.
Not one that has been not recently. Nobody's knocked or not knocked, I suppose, on the door. But now, pragmatic. I mean, all of that is, of course, interesting, and I think interesting to me and a lot of people. But this is also kind of profound, pragmatically and politically, because forfeiture has been a very, very powerful tool at the state level for getting budgets for police departments and for a number of things. So what are your pragmatic takeaways on the fact that we're now going to have the excessive fines incorporated? I mean, it seems to me, as one who takes a look at state and local government pretty quickly, this is going to have a relatively profound impact on day-to-day operating procedures in some states.
Yeah, I mean, maybe it'll speed up the drive for marijuana legalization because the states won't be able to make as much money impounding cars driven by marijuana dealers anymore.
Well, and it could free up our social media feeds from their busts that they always post.
Yeah.
Wait.
Yeah. So yeah.
Well, no, I mean,
I don't know. No, I didn't mean.
Continue,
Actually,
so
I meant to let you continue. I'm sorry.
Well, no, what's interesting is, and I agree with you. I actually wanted to head marijuana, but I don't know if you were going to go that way or not. So let's just head that direction. I mean, this has been the way. I mean, because you transport marijuana in something and you can forfeiture. I mean, as a matter of fact, it goes so much so that I mean, just the money that people have on them will sometimes be taken because, well, that's probably what you were gonna buy it with. Um, and I mean, I know that sounds like a joke, but I mean, it really could be the case that not having that means there's a whole lot less reason for state governments to want to prosecute drug
Yep.
laws because they're going to be a whole lot less lucrative to them, their bottom lines as police forces.
Yeah, I mean, in the Timbs case itself, which you already described the facts of, I think Timbs was selling $225 worth of heroin, and the crime subject him to a $1,200 fine. But they took his $42,000 Land Rover because he was driving it while he was selling heroin. So
right.
yeah, I think it'll have some fiscal impacts on those kind of municipalities that do use it a lot for sure.
And in all seriousness, do you think this will have an impact on especially inner city drug crime prosecution?
Yeah, I don't know. I guess it depends how mercenary of a view you take about why they do so much of that kind of prosecution, right? I mean, if you
Well, I'm going to put myself out there. I'm relatively mercenary. It seems relatively mercenary to my
yeah.
point of view.
You,
But again, I recognize that's a particular
you
point
think
of view.
you think they do it because they want to forfeit all these assets, and that's why they do all these arrests and prosecutions.
I knew. I mean, I think it explains the reason why it appears that, statistically speaking, those kinds of things are prosecuted at a higher rate than are other kinds of crimes, and especially in the disparate areas that you see. Right? I mean, you don't see that kind of behavior happening in middle class neighborhoods. You do see that in where I think you're going to get your hands on some better stuff. So I'm not suggest. I would suggest that race plays a role
Yeah.
as well, but I would say race combined with money in this case. So I just didn't know if you had any thoughts on that or not
Yeah,
yourself,
I
Ken.
guess I probably subscribe more to the view that a lot of the war on drugs was more racially motivated than motivated by civil asset forfeiture. So in that sense, I probably see less of a change coming than what you're predicting. But I don't, yeah, but I don't know. I really don't know. I mean, this is my crystal ball is not very well shined on this one, and I don't know what's going to come.
Well, and it's difficult when you have this because this is a significant change, and that it'll be interesting to see what continues to come out of that. And in all honesty, I don't think this got enough attention this week. I think it's a pretty big deal, one of the reasons I wanted to kick off the Wednesday show with it. Now, another issue that has come up this past week, and now this one is not. I mean, this is not in the past yet, so it's a lawsuit that's ongoing. Is that there was a lawsuit filed against President Trump and Secretary of State, the Secretary of State, and it comes among legal questions about foreign terrorist fighters, whether they have been captured or whether they become embedded. In other words, they want to go to ISIS. And both in the United Kingdom and here in the United States, we call this kind of the ISIS bride phenomenon. So potential citizens who are going over to kind of join ISIS. And what's happened recently that's brought this back to the center of attention is that a 24-year-old Honda Mathana, who was born in New Jersey, is wanting to return to the United States after having headed to the area controlled by ISIS to be part of the Islamic State. Now, what the interesting wrinkle in this is that you might say, well, look, this is a pretty open and shut case because she's born in New Jersey and therefore you have birthright citizenship. However, she was actually born to a Yemeni diplomat father. And what that potentially means is if she was, that she would not be eligible for birthright citizenship. As a matter of fact, Donald Trump has even been tweeting about this, arguing that, quote, yeah, he's not going to allow her back into the country, exclamation point. At least he didn't make it all capitals, though. So I points to you, President Trump, this week for the use of punctuation. and arguing that she is not, in fact, a U.S. citizen and is not going to be admitted back in the United States. So the case that has opened up is her father is suing on her behalf, and the crux of the argument here is that he was no longer a diplomat at the moment of her birth, and therefore she is an American citizen. But what's both interesting in this is you have the idea of whether or not she's a citizen, which is a fast kind of a interesting technical and legal question, but also what ought we to do. And this has been a big one in the United Kingdom, probably even more specifically here in the US, with individuals who say, oops, I made a mistake. How do we treat this kind of scenario? And as the war on ISIS continues to kind of wrap up, potentially, this will probably continue to be an issue. What do we do with these individuals? Do they have a right to return, as Jeremy Corbyn of the United Kingdom argued, or not? And what do we do with that? So, Ken, thoughts on the ISIS bride cases emerging this week?
So from a constitutional standpoint, it is going to matter whether she was born while her father was in diplomatic service or not, because a diplomat who could claim diplomatic immunity is not subject to the jurisdiction of the United States within the meaning of the 14th Amendment. And so all natural born, all persons who are born in the United States and subject to the jurisdiction thereof become citizens. Yeah.
And that's the key, subject to the jurisdiction
become
thereof.
Citizens at birth. So I think there's certainly a valid argument that if her father was in diplomatic service at the time, on the day of her birth, he could have claimed diplomatic immunity. If he'd been charged with something, then I don't think she has U.S. citizenship, or doesn't, or it can be certainly taken away. On the other hand, if she, and I know there's some factual controversy about when she was born and when her father left diplomatic service, but
that is the crux of the case.
So if she was born in the United States at a time when, even if her father was no longer lawfully present, that wouldn't really matter. As long as she was born here and he was not in a position to claim diplomatic immunity at the time, then she would be a citizen under the 14th Amendment. And there's a case, I don't know if you've run across this one, but there was an old case from 1958 called Trope versus Dulles, which addressed.
Oh, I'm not familiar with that.
This addressed the question of whether you could revoke someone's citizenship as punishment for a crime. And Trope v. Dulles squarely holds that that would be a violation of the Eighth Amendment cruel and unusual punishment clause. So someone cannot lose their citizenship as punishment for a crime, if they have citizenship. So I know some of the public discourse has talked about, well, even if she is a citizen, she should lose her citizenship for this, but that wouldn't be possible under Trope v. Dulles. So I think, to me, the whole case is going to come down to the resolution of one of the most contested facts in it, which is what was the status of her father at the time she was born in the United States.
Now, in general, though, and this, I think, raises the larger political question that I don't think is going to go away, although it's certainly not going to be hundreds of people. But what is the right kind of response when you have individuals who either, if she does in fact have American citizenship, in a sense, defect isn't the correct word here, but who take up arms against the United States? What do you do with that? I think is in fact a worthwhile policy question. And so what do you think about that question, even a little more broadly than just in this particular case over does she or does she not have citizenship?
Well, this came up in the early years of the war on terrorism. So in the immediate aftermath of September 11th, there were a few U.S. citizens who were fighting on the behalf of the Taliban and Al-Qaeda and who were picked up. And one of them was a famous case, although it didn't get to the Supreme Court, but you probably remember it. There was this guy, John Walker Lind, who was considered the American Taliban. Yeah.
Oh,
and
right.
So he was brought back and he was picked up by the army in Afghanistan. He was brought back. He was charged with crimes in an ordinary criminal trial in civil court, not a military tribunal or anything like that. He got sentenced to,
because he had citizenship.
He lived his whole life in the United States until the year or two before he went over there a year or two before, the September 11th, and but yeah, so he would.
It was like 1999
Yeah.
or something,
and
wasn't
he
it?
got picked up. So I say he got sentenced to 20 years in prison. He actually, I think, did just come out. He got sentenced to 20, but I think he served about 17 and got out a little early. So I think he's out of prison now. And
Oh,
the other one, which did go all the way to the Supreme Court, and which might be even a little more on point here, there was this guy named Yusuf Hamdi, and I'm sorry, Yezer Hamdi. I was almost confusing with Yusuf Hamdan, but this was Yezer Hamdi. Yeah, Yezer Hamdi was
yeah.
a guy who had been born in Louisiana and but hardly lived here. He was back in the Arab world by the time he was about 1 year old. So he grew up entirely outside the United States. Didn't even speak English, but he had U.S. citizenship from birth, and he became a Taliban fighter, and he got picked up and sent to Guantanamo. And while he was in detention at Guantanamo, he took his case to the Supreme Court and argued that he shouldn't be able to be at Guantanamo because he's a U.S. citizen. Everybody else in Guantanamo were foreign citizens. And the court divided into three groups on this. There was no single majority opinion. And
A rare occurrence, actually.
The plurality opinion by Justice O'Connor found it relatively irrelevant that he was a U.S. citizen, and said that if he took up arms against the United States in a foreign country, he could be treated as an enemy combatant and subject to all of the ordinary incidents of force that a captured enemy combatant would be subject to. So that if other prisoners of war that were picked up were being held in Guantanamo, then he could be held in Guantanamo, and it just didn't really matter that he was a U.S. citizen. That's what the O'Connor opinion said that got the most votes. Now, I'm going to say I actually agreed with. There was an unusual pairing. There was one opinion written by Justice Stevens and Justice Scalia together. So that at that time would have been probably, I'd say Scalia would have been probably the second most conservative justice on the court next to Thomas, and Stevens was probably the most liberal, or maybe the second most liberal next to Ginsburg. But they wrote together, just the two of them. Nobody else joined their opinion. But they disagreed with the O'Connor opinion in a way that I found persuasive. And they said that if he is a U.S. citizen, then that actually makes his actions treason, which they wouldn't be if he wasn't a U.S. citizen. And if his actions were treason, then under the Constitution, that means that he must be tried in an ordinary criminal court, not only with a fair civilian criminal trial, but actually with heightened evidentiary standards. But it also means that there's the potential of a death sentence, which would not be something you could apply to prisoners of war, right? So the people who are being detained in Guantanamo could not be summarily executed, but somebody
Right.
for
But
treason,
you can
yeah.
for
So if you
treason.
convict someone for treason on that heightened evidentiary standard, that's a crime, and that's a crime that only citizens can commit. So the O'Connor opinion really, yeah.
Well, and I'm glad you bring that up. And I don't mean to sidetrack you there, Ken, but one of my questions about these cases is, and this is not one that I have an answer to, is that I think most of us who look at this, even from a semi-scholarly point of view, say, well, what is then the standard of treason? So if heading over and taking up arms with ISIS doesn't count as treason, what would? So what is that? Is there a constitutional standard for treason?
Yeah,
I'll be
that would
honest, I
count
don't
as
know.
treason. The constitutional standard relates more to evidentiary standards than to the definition. So there have to be witnesses to overt acts who can testify about them, and that's required by the Constitution in a treason trial. Now, if you didn't have that level of evidence to prove out treason at that standard, then there's still a lot of other lesser crimes that could easily be proved out, and that's what happened in the John Walker Lind case, right? He didn't actually get convicted of treason, but he got convicted of various crimes of violence, and that's how he got the 20-year sentence. So I think like the Lind case is one model for how this could go, but the Hamdi case, it has these interesting sort of disjunction where the O'Connor opinion had more votes and ultimately said that even though Hamdi was a citizen, he could just be left at Guantanamo as a prisoner of war. And so that's one approach. But I'd say personally that's not the approach that I think is the best approach. I think the best approach would be to say, bring a citizen back, try him for treason, try him for lesser crimes if you can't prove out treason, give them an ordinary, fair federal trial in a federal court, perhaps before a jury if they want a jury trial. And some of these people might not want a jury trial; they might actually ask for a bench trial. And then
Yeah, I would imagine that you probably wouldn't want one, given that.
given the passions in the citizenry about these issues. So it's So I think that's a better way to go. So that would be my preferred, but that's not the Supreme Court was certainly open to other methods other than that.
Well, Ken, it was wonderful talking about this with you. And I will say that I hope, listeners, that you enjoyed our week of constitutional law and legal questions, because I think that's really what we had this week, didn't we, Ken, between the weekend and today's show, the Wednesday show. But, it's always kind of fun to kind of get a little bit deeper, and I hope you all enjoyed that as well, a little bit deeper into kind of the legal side of things, and to kind of talk about a few policy issues in a little bit more in depth. So I hope you've enjoyed that as much as I've enjoyed. So, Ken, it's been wonderful chatting with you again here on Wednesday.
Thanks for having me.
Yeah. And listeners, if you have liked what you've heard, I'd ask that you would subscribe to us on iTunes, rate us on iTunes, recommend us to a friend. It's amazing how much just one recommendation or one post on social media can do for us. And if you want to go to the next level, don't forget, Ken and I actually this past week had some very fascinating bonus show topics relating to the case against the Washington Post. So if you want to hear that, become a supporter. Supporters get a bonus show on the weekend. The executive producers of the Politics Guys are Michael Baranowski, Jay Carson, Bruce Johnson, Wilmer Marino, Benji Fishman. Today's show was produced by Trey Orndorff. We'll be back with a new show on Saturday. I hope you'll join us then.